Welcome to Do It for the Case Law for Friday, August 21st, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 53 cases across 10 circuits. Our coverage includes criminal justice matters with James Taylor, civil rights and Section 1983 litigation with Aisha Johnson, constitutional law and habeas corpus updates with Michael Reeves, business and labor disputes with Maria Santos, and immigration and government agency reviews with Patel. Please subscribe to the show for daily federal appellate analysis. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 22 cases on the docket today across 7 circuits. The disposition mix includes 15 affirmances, 1 denial of rehearing en banc, 2 reversals, and 4 vacatures or remands. Let's start with the split outcomes and significant movements first. Over in the 11th Circuit, the court vacated a sentence and remanded for resentencing in Victor Uriel Diego Estrada because the district court failed to make explicit factual findings regarding co-conspirator liability enhancements under USSG Section 1B 1.3. The court also vacated the judgment against Nicole Robin Roy due to her death during the pendency of her appeal, though it affirmed the conviction and sentence of Harrison Edwin Dudley for child neglect and endangerment under the Major Crimes Act. Moving to the 9th Circuit, the court vacated a district court order granting summary judgment in State of California versus ATF, finding that neither California nor the Giffords Law Center had Article 3 standing to challenge the ATF's Example 4 rule on firearm parts receivers. In the 3rd Circuit, the court reversed a grant of a new trial in United States versus Philip Epps, holding that the district court's instruction to a deadlocked jury was not unduly coercive despite telling jurors they must reach a unanimous verdict. Now for the affirmances and denials. In the 1st Circuit, the court affirmed summary judgment to police officers in Hurley, Catanese, and Skeffington, all involving Fourth Amendment claims regarding warrantless entries into a sober home in Falmouth, Massachusetts, where the court found qualified immunity barred most claims and evidence insufficient for others. The 1st Circuit also affirmed the conviction of Correctional Officer Seth Burgett for excessive force against an inmate, finding malicious intent supported by the use of a shield as a weapon. In the 10th Circuit, the court affirmed the denial of compassionate release in United States versus Rose, noting that the district court provided 2 independent grounds for the denial and the defendant failed to challenge both. The 11th Circuit issued several affirmances on non-argument calendars. It upheld a conviction and sentence for felon in possession in United States versus Nathaniel Shamad Braxton, rejecting Second Amendment challenges under binding precedent. The court also granted summary affirmance in United States versus Niskewe Ray Brown regarding the denial of an out-of-time appeal notice and affirmed a supervised release revocation sentence in United States versus Trenton Edward Watkins. Additionally, it denied compassionate release in United States versus Vanessa Vanley Kaiser, finding no extraordinary and compelling reasons existed. Moving to the 4th Circuit, the court denied a petition for rehearing en banc in United States versus Christopher Clark Arthur, leaving intact a panel decision upholding a conviction against a First Amendment challenge to a federal statute on explosives information distribution. Judge Gregory dissented, arguing over breadth. The 4th Circuit also affirmed the felon in possession conviction of John Robert Williams III, finding sufficient reasonable suspicion for the stop and search. In the 8th Circuit, the court affirmed Jermaine Hester's firearm sentence, rejecting procedural and substantive reasonableness claims. Finally, in the 9th Circuit, the court affirmed Felix Cisneros' bribery sentence involving a high-level DHS agent, upheld Kalen Jacali Wendell's 240-month sentence for fentanyl distribution resulting in death, and affirmed Garrick D. Richardson's conviction under the felon in possession statute in the District of Columbia Circuit. The D.C. Circuit also affirmed convictions for conspiracy to commit Hobbs Act robbery and brandishing a firearm in United States versus Enyina Onyewu. Back to you, David.
Thanks, James. Let's turn to Aisha for the civil rights coverage.
Thanks, David. 12 cases across 4 circuits. The disposition roll-up includes 1 split outcome, 2 affirmances with reversal in part, 1 remand, and 8 affirmances or dismissals. Starting in the 11th Circuit, the court affirmed in part and reversed in part a Title IX and Section 1983 case against Fulton County Schools, holding that a jury could find deliberate indifference for hiring a teacher with known misconduct history, but upheld summary judgment on the school's response, liability, and all Section 1983 claims against individual principals. The circuit also dismissed sua sponte a petition by Jonathan Lewis against the EEOC Miami Division for lack of jurisdiction, noting that direct appeals to the court are not permitted and district court's civil actions are the proper remedy. Moving to the 4th Circuit, the court affirmed in part and reversed in part a jury verdict in Christopher Billiston versus Wells Fargo Securities, sustaining an ADA retaliatory discharge claim but reversing on failure to accommodate and disability discrimination theories because the employee was already working remotely indefinitely and his disability was not the but-for cause of termination. In contrast, the Fourth Circuit affirmed dismissals in Kevin A. Jenifuja versus Edward Owusu and Monica Ussery versus Eddie Buffalo based on res judicata and qualified immunity, respectively. The circuit also remanded Nneka Henderson versus W. Townsend for a ruling on a Rule 60 motion after the district court indicated it lacked jurisdiction but would grant relief if the case were returned. Over in the Sixth Circuit, the court affirmed summary judgment for the City of Hamtramck against plaintiffs challenging Resolution 2023-82 under the First Amendment, holding that flagpoles became government speech via a tightly controlled closed-list system. The circuit also affirmed denials of judicial immunity in 2 cases, involving a judge who handcuffed a student and held a mock trial on YouTube, ruling these acts were not normally performed by a judge and lacked official capacity. Finally, in the Ninth Circuit, the court affirmed in part and reversed in part a prisoner's case against Johnson, reversing dismissal of state law claims for sovereign immunity reasons while upholding qualified immunity denials on due process grounds. The circuit also reversed summary judgment on Title IX and Washington law against discrimination reasonable accommodation claims for 3 employees, but affirmed for 2 others due to procedural failures. Additionally, the Ninth Circuit dismissed an appeal by the Republican National Committee versus Burgess for lack of Article III standing because the plaintiffs admitted they would voluntarily dismiss if the order were vacated. Back to you, David.
Thanks, Aisha. Now to Michael for the constitutional law updates.
Thanks, David. We have 6 cases in this block from 4 circuits. The disposition mix includes 1 vacatur and remand, 1 split outcome, 2 dismissals, and 2 affirmances. Starting with the 11th Circuit, the court vacated and remanded John J. Wilson, Jr. versus the Secretary of the Florida Department of Corrections after finding the district judge abused discretion by failing to treat the inmate's objections as a motion to amend his complaint under Federal Rule of Civil Procedure 15, allowing him to proceed despite not yet receiving a response from defendants. The same court affirmed the denial of post-judgment relief for Edward Verdi Bruno versus the United States, rejecting his pro se arguments that a clerical error in his presentence report regarding Puerto Rico's status or alleged attorney fraud on a plea form warranted correction under Federal Rule 1636. Moving to the Sixth Circuit, the court affirmed summary judgment for prison officials in Jacob Julich versus Scott Jordan and others, ruling that the inmate failed to prove excessive force or cruel conditions because the use of pepper spray was a proportional good-faith response to his disobedience rather than an act done maliciously to cause harm. In the Ninth Circuit, the court split its decision in Mason versus McComber, affirming the denial of habeas relief on most grounds but reversing regarding trial counsel's Sixth Amendment violation for conceding guilt on criminal threats and negligent firearm discharge charges against Nathan Mason's express instructions under the standard set in McCoy versus Louisiana. Finally, the District of Columbia Circuit dismissed David Radomatkin versus Daniel Driscoll in 2 separate filings involving his appeal from military service proceedings, establishing that a pro se notice of appeal can be construed as a motion to extend time under Federal Rules 4 and 6 if it explicitly acknowledges lateness, explains the delay due to lack of notice, and requests relief. Back to you, David.
Thanks, Michael. Let's turn to Maria for business and civil law.
Thanks, David. 10 cases today across 6 circuits with 2 reversals, 1 split outcome, and 7 affirmances or dismissals. We start in the First Circuit, where the court dismissed an appeal for lack of finality because a remaining counterclaim could be revived, then affirmed a dismissal of an insurance coverage lawsuit against Marsha McLennan due to insufficient pleading. Moving to the 10th Circuit, the court affirmed the denial of a habeas petition in a capital case, finding the state court did not unreasonably apply Supreme Court law regarding lesser-included offense instructions. In the 11th Circuit, the court affirmed dismissal for lack of standing but vacated and remanded a breach of contract suit against Harvard University to allow for a judgment without prejudice, while also affirming the denial of a habeas petition where ambiguous impeachment evidence was not crucial to the conviction. Over in the 6th Circuit, the court reversed in part and remanded a securities fraud class action, holding that the district court abused its discretion by denying class certification based on market efficiency theories. Finally, the D.C. Circuit affirmed summary judgment in a medical malpractice case where expert causation testimony was excluded, reversed a damages award in a fraudulent misrepresentation claim against James O'Keefe because protected speech was the dominant cause of harm, and denied review of an NLRB order regarding labor picketing at Millennium Towers. Back to you, David.
Thanks, Maria. Raj has the immigration and government cases.
Thanks, David. We have 8 substantive cases today across 4 circuits. The disposition roll-up shows 1 vacatur and remand, 2 affirmances, and 5 denials or dismissals. First, in the District of Columbia Circuit, the court vacated and remanded a district court's preliminary injunction against the Office of Management and Budget regarding Memorandum M2513, holding the challenge moot because the policy no longer exists and there is no expectation it will recur. Moving to the Ninth Circuit, the court dismissed a petition challenging an underlying removal order for failing to file within the mandatory 30-day deadline while affirming the Board of Immigration Appeals' denial of a motion to reopen based on vague evidence of changed country conditions. In the 11th Circuit, the court dismissed an appeal from Eastwood Village versus Larry Williams for lack of subject matter jurisdiction, ruling that orders remanding cases to state court due to jurisdictional defects are unreviewable on appeal. The same circuit also denied 3 immigration petitions. Domingo Emilio Rojas's request for review regarding a frivolous asylum application finding Masri Sastrawan's motion to reopen removal proceedings based on alleged changes in Indonesian country conditions, and Rishi Ramdial's petition where the court upheld the conviction for robbery by sudden snatching as an aggravated felony under federal statute. Finally, in the Federal Circuit, the court affirmed a veteran's claims decision denying an earlier effective date for a PTSD claim, holding that the regulatory amendment applied prospectively rather than retroactively. Back to you, David.
That wraps up today's Friday, August 21st, 2026 broadcast of Do It for the Case Law. A massive thank you to our reporters who covered the docket: James Taylor with 22 cases, Aisha Johnson with 12, Michael Reeves with 6, Maria Santos with 10, and Raj Patel with 8. The most significant outcome of the day was a single reversal or remand decision. We saw 36 affirmances across the circuits, 10 other dispositions, and a number of appeals were dismissed on procedural grounds without reaching the merits. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Subscribe to the show and follow us for more federal appellate coverage.